Perfect. So we're just waiting probably about another minute or two to have a few more people join in. Thank you for joining us tonight. I think this is going to be kind of a intimate group to be able to go over this interesting topic, one of which can sometimes be incredibly intimidating if you haven't seen a contract before. Sometimes they can be rather lengthy or seem like they're in a different language as far as the vast spectrum of contracts. So hopefully we can dive into some detail or go over generalities. And I think that this is going to be unique because you're going to hear it from a perspective of an employee perspective, that of an employer, as well as that from our legal counsel. So let's just wait another minute or two and then we'll get going. All right, so we have our three moderators all logged in. I'll start by handing the mic over to Dr. Samir Vakil. If you don't mind kind of telling us a little bit about yourself, Dr. Vakil.
I graduated Barry in '91, so I was the third graduating class. I did my residency in Pittsburgh. I joined a practice in Punta Gorda, Florida in '93 and have been there ever since. We've grown to 2 offices and 4 physicians, all of whom are partners now. And so I will be kind of representing the employer side. And so I'll probably be the most contentious person on the call. But I want you guys all to think, don't think as an employee. I want you to think about 5 years out when you're in practice and hiring another associate. Okay, what you have to do to protect your business and your reputation. As a new associate, you don't have a reputation. So when you join a practice, you are joining that practice's reputation. And so you should definitely evaluate that reputation before you consider it, because you have to trust them and they have to trust you. Okay.
Very good. And Mr. Winn, do you mind chiming in?
Absolutely. I'm Jason Winn. I am the General Counsel for the Florida Osteopathic Medical Association, as well as the Florida Podiatric Medical Association, as well as the Florida Prescription Drug Monitoring Program. I have been an administrative law attorney now for about 15 years here in Tallahassee. I advise the general membership on legal issues. I do not represent any individual members before the board of podiatric medicine on any issues. I represent the association as a whole. I am happy to give you advice and counsel as the general counsel to the FPMA. And if you have questions afterwards, my contact information will be there, and I can certainly point you in the right direction on any questions you have about contracts or any other legal matters. So thanks for joining us.
Absolutely. Thank you both for being here. I'm Larissa Schmidt. I practice here in Central Florida. I did the Ohio College of Podiatric Medicine, which is now Kent State. We were the first graduating class from the new campus. From there, I did my residency program at Florida Hospital Orlando, which is now Advent Health. I first started out as a newbie in an ortho group, so I had about 2.5 years of experience there. And from there, I joined one of my other attendings within a podiatric practice. So I've kind of seen quite a few variety packs as far as contracts within my time in practice. So thank you again for joining us. We're glad that this is not a huge format. So if you do have questions, we'd be happy to entertain them throughout. In regards to the structure of this talk, we're going to kind of define some generalities and jump into what you might see or expect to find within contracts. And again, you'll hear kind of a little bit of back and forth between pros, cons, things to consider if you're new or if you've been in practice for a while. And also, you know, the opinion of the other side of the table per se. So I think this should be a good learning perspective, a glimpse into maybe your future, who knows? We don't want to sideswipe anybody, you know, sometimes these things can be unexpected, but I think that this is going to be some good information for those who've never seen a contract either. So Aless is going to pull up our slide deck and we'll dive on in.
Do you want me to handle the disclaimer slide
Sure.
as counsel? Okay. So this is, there's two disclaimers. This is not a lecture to tell you how much you should get paid. This is the lecture to discuss types of contracts and considerations to help define your role in practice. And one more disclaimer is I am not your attorney. I can certainly give advice and point you in the right direction, but that's one more disclaimer for there. All right, the next slide. So in the very beginning, we talk about the basics. What is the contract? What is a contract? All of us have probably throughout our life at this point signed many contracts that have a lot of verbiage. If you've ever bought a vehicle, it's got a lot of pages. I don't know if you've ever read the fine print, but everything in there was written by a lawyer for a reason. So when you look at a contract, you need to make sure you understand the entirety of the contract that you are signing, whether you're signing as an employee, or as Dr. Vakil said later down the road, as an employer. Also, when you're signing contracts with vendors or third parties that may be providing services to your office. So a contract, very simply put, is requires an offer. It requires an acceptance of that offer. There has to be a consideration, either money or a bargain for exchange of services, and then no valid defenses. If there is a contract by an offer or acceptance, whether it is oral or written, it is enforceable as long as there is consideration. You cannot, as we know, enter into a contract for an illegal service. So that would be a valid defense to any contract that you signed, that then you would be able to argue the valid defense of the legal manner of the contract itself. Also, make sure that when you do accept the offer, that you understand what the offer is, whether there's addendums or schedules. A lot of the contracts have addendum pages, have schedules to the pages, have payouts. All of that may not be inclusive in the contract that you sign. So you want to make sure that you see all of the appendixes or any of the other documents that are related to the contract you're signing, to make sure you know everything that you are signing and accepting. So offer, acceptance, consideration, no valid defenses. You got a contract, you put your signature on it, you're going to be held to it. And I will fight Dr. Vakil later for the most contentious presenter when I delve into the Florida statute on non-compete clauses. So I'll give you a run for your money. Next slide.
So at this point, we're going to dive into things that the contract may or may not include. These are valuable points, and I think that these are going to be the most tangible for practitioners rather than the legal language. These are things that define kind of your salary, things that you might be responsible for. And I'll cover the first kind of two chunks, and Dr. Vakil will take over from there. So the thing that we, skim through and look past and try to get directly at is your salary structure. There are a lot of different measures or methods that are defined for salary. And in my opinion, some benefit newer practitioners versus those that have been in practice for a few years and are established. I'd have to say that the most common salary structure that you will find for practitioners is the base with the bonus. What that means is that you're allotted a certain amount as a base, and that could be divided up per month or a certain amount per month. They will set a goal that is typically, 3 to 4 times the amount of that base in collections before you can obtain a percentage bonus. So for example, lowballing it, just throwing out some easy numbers here, say that your base will be $100,000 and the bonus structure would be $300,000. After you hit that $300,000 in collections, say you get anywhere from 15 to 30% of the monies made after that 300,000. So I'd say that could be a common thing that you might run into. It is predictable being a new practitioner because you might not be busy to start within the first few months. You're going to be out marketing, you're going to be promoting yourself, you're going to be covering potentially hospitals where insurance may or may not be present for some patients. So the base structure is safe in a sense because it's not as much fluctuation. It's a little bit steadier, predictable source of income. And then you work your tail off to kind of get that percentage of the bonus. Another structure that's a little bit similar, a little bit different is that of a draw salary. What that is defined between you and your employer saying, listen, I need this amount per month. And with that amount, we would then work on working on collections until you obtain that amount. And then afterwards, you would get a percentage of that. So the difference of that versus the bonus structure is that it is sometimes it's kind of like a game of chase where in a draw salary situation, you might get that bonus a little bit sooner than the base with bonus, which sometimes is evaluated at the end of the year. I was in a situation where I was in a base with a bonus, but it was broken down quarterly. So that was good things, bad things. If you had a slow quarter, you might not have hit that particular bonus versus waiting till the end of the year where it's likely that you had a lot more activity under your belt. Another salary structure that you might run into is that of percentage. That is literally the percentage of your collections after, potentially some, well, it completely depends, but just say that you have a certain percentage of what you bring in. And in that structure, I would say that definitely benefits people who are busy. If you're not busy, that is a little bit more risky on your behalf because that does fluctuate based on activity. So I would say that a lot of times you start off with a base and bonus. And after a couple of years in practice, it's common to then face a percentage structure. And a lot of larger groups, also in hospital systems, rather than a percentage, is based on RVUs. RVUs is a certain value that is identified per procedure, per interaction with patients. And the RVU structure is potentially percentage driven as well. So those are, I'd say, the most common salary structures that I've seen, that I've heard of, that I've read about. And I think, again, there's pluses and minuses to each from the standpoint of an employee. Real quick, before we move on, Dr. Vakil, do you want to comment on any of that from the employer standpoint?
Yeah, I think you hit a lot on good points on the base plus bonus. And when you're looking at a practice, you need to ask the employer, what's your time for a new patient to get in? Okay, and so, I had a lecture once and they said, okay, if you are booking out more than 3 to 4 weeks out for a new patient, that's when you should be bringing in an associate. Okay, because that's where we try to have our associates take on the majority of the new patients, because there's more money in the new patients. Plus, when you're taking hospital call and hospital consults, they pay better. So your per patient value is going to be higher. then maybe even the partners and stuff at the beginning and stuff while you're building your business, because your new patients and your hospital calls and your hospital surgeries and stuff are going to bump your per patient value up. And so you want to make sure you're joining a practice that has enough volume that's going to be able to support that. Okay.
Yeah, all good points. You definitely want to get a feel for what the environment is that you're jumping into. And a great way of doing that is shadowing or looking up some good questions, getting a feel of exactly what he's saying, how willing people are to put patients on your schedule. Also, in lieu of things that will directly affect you, some contracts do define how much and how frequently you do have to take hospital call. Some practices, that's just not part of the mix, but hospital call can be a significant amount of time outside the office. It sometimes requires moving patients around upon emergent procedures. Sometimes it's multiple hospitals that aren't directly next door to your office. So that's something that you really want to get a pulse on before joining, is the responsibilities of call. In regards to that too, it might pull over to urgent care centers, people being able to reach you guys directly. So your availability is important to the employer, and it may be defined in your contract. Other things that will affect you are potential vacation times, sick days away, as well as how many days out of the year you can take for CME or for just general vacation. If we can move on to the next slide. I'm so sorry. Sorry about that, guys. Okay, so I was tasked to cover this topic. I have no idea why, but sometimes contracts define maternity leave. So if you, luckily for me, in all 3 contracts I've been through, it wasn't necessarily written on paper, but more or less a conversation with the employer. And I threw this in here because even if it's not on the ledger, I think it's something to kind of discuss if you have plans for starting a family, especially being a female surgeon or practitioner. So you can see amongst other doctors in a group if they've kind of gone through this process, if there's anything set as far as a standard. In regards to this, if it's your first child versus multiples, I will tell you, first child, all you want to do is be home, so you might require a little bit more time versus the second or third, or however many little rugrats you have. In regards to this, it's important to establish a plan, because when you're out, who's covering your patients? Is there any definition as far as once you return, how frequently are you going to be in the office? How are those patients going to kind of come back to your schedule? So though it might not be necessarily written, I think this is something that's important to discuss while you do talk contracts. Short-term disability is a potential benefit that employers provide. And if it is not a provided benefit, there are ways of obtaining it. And some of those clauses state that you have to have a policy for a certain amount of months before actually enacting it. So that's something else to keep in mind. If we can move on to the next slide. All right, and I'll pass this over to Dr. Vakil.
So in your contract, you need to review what's included in your perks package, because in our contracts that we give out and stuff, it accounts for $25,000 to $35,000 that we're putting out toward them. Your malpractice, it starts slow and stuff, but it's eventually going to get to $10,000, $15,000 a year. Your membership dues, of course, we're going to say here, we want to cover your APMA, FPMA, and your county dues. You also have to have dues for if you have a regional medical society, a regional physician hospital organization, PHO. In addition, who's paying for your staff privileges at all the hospitals, because they're $500 to $1,000 per hospital. And insurance, the majority of the time, if you legally, if the doctors have health insurance, the staff has to have health insurance as well. And so the associate and my employees, we cover 90% of their health insurance. Okay. And I think even for the associates, I think we cover 100%. As the partners, even though we're paying for the insurance, because you're a partner, the government sees that as income for you. And so at the end of the year, if my health insurance was $20,000 for me and my family, they're going to add that on as income, as a partner, but not as an associate and not as an employee or a staff. 401k, traditionally, you have to be an employee for 1 year and 2,000 hours of work to be eligible for the pension plan. And everybody's pension plan is different, but you want to make sure you ask for all these benefits in advance if they're not in there while you're doing the negotiation. Okay, CME, we usually say here, we're going to give you one CME up to, I think, $2,500. And sometimes we want them to come to our FPMA SAM conferences and stuff because they get the Florida credits as well. Mileage stipend we usually don't do because as an associate, your moving expenses as well as all the mileage that you do are tax deductible. Books, online courses, we're usually pretty lenient with that. If somebody wants a book or something online, we don't have an issue with that. The continuing education goes back to the CME as well.
All right.
Okay.
And now we're going to get into some of the juicier, the content, the little bit more controversy. And Dr.
Okay.
Vakil, if you don't mind diving into some.
Yep. So your initial contract is probably going to be 1 year. Okay. And it's like the honeymoon area. And so you have to make sure you're comfortable with them and they have to make sure you're comfortable with you. From then on, you can always do a 1 year, 2 year, whatever you feel comfortable with contract moving forward. Partnership track, you want to make sure that there is a ability to become a partner and what that means. What kind of perks are you getting for a partnership? What's it going to cost you to buy in? It's usually a percentage of what the practice is valued at. And the partnership, you have objective and you have subjective standards, and they may not discuss all the specifics at the beginning because you're not a partnership material at the beginning. Objectively, that's easy. You can say here, you have to generate whatever, $500,000, $600,000 a year, for 2-3 consecutive years. The subjective is a little bit more tricky. You have to be a partner mentally as well. We have to see you as being partnership material. Do the referring doctors like you? Do your patients like you? Does my staff like you? Are you respective to the patients? Are you respective to the other doctors? Do we get a lot of complaints about you? And so the subjective is almost as important as the objective portion of it before you become a partner and stuff. And eventually when you become a partner, they're going to give you some tasks that you're going to be responsible for. You're in charge of educating the medical assistants. You're in charge of helping with the bookkeeping, something. And so, as you become an associate, and you're on your way to partnership track, they're going to start discussing all these different items with you. But it's a marriage. They have to make sure they're comfortable with you, you're comfortable with them.
All right, thank you. So we're going to pass the torch to Mr. Winn to kind of dive into some of the legalities of contracts. So hold on to your hat for the quote unquote most contentious portion of the lecture. So we'll see how this goes.
Yes. Thank you, Dr. Schmidt. So when we're talking about the contracts and what they define, one additional note I'll make now about the previous slide on the salary structure and a case that I dealt with a client before within another profession. They received a sign-on bonus when they signed the contract to begin work at the facility. They eventually terminated the contract before the expiration date. And based upon the termination, the employee had to pay back that sign-on bonus with a sliding scale. So it became less over time, but any sign-on bonuses that you receive, if you leave early, you will be held liable or responsible to pay those back. So a non-compete clause, which you will probably see on all of your contracts. You may even see that on some vendor contracts, but most specific to your ability to practice as a podiatric physician in the state of Florida, should you leave that place of employment. And one thing to note, it doesn't matter if you leave early, if you are terminated and leave early, or terminated early, or you terminate them and you leave early, or you stay the entire term of the contract and then leave. In any of those scenarios, the non-compete clause will still be in place. And what the non-compete clause can say is you are restricted from working within a certain geographical location. You are not allowed to work at any of the facilities that are owned or are sub-entities of the employer. And that duration as an employee, once you leave, can be from anywhere from 6 months to up to 2 years. Any of these arguments require the court's interpretation, because the statute simply says, talks about reasonableness as it relates to an employer, as an employee, reasonableness as it relates to the amount of time, and reasonableness as it relates to the protection that is the underlying reason for the non-compete statute. There is a specific Florida statute, 543.335 is the Florida statute for non-compete clauses. And it has language in there that talks about the length of time. It does not have language specific to the geographic region. It just says a specific geographic location. So your non-compete could be, for instance, if you're working in Miami-Dade County, the non-compete could say you can not see any podiatric physician or podiatric patients in Miami-Dade County for a period of up to 2 years. And that would be a valid non-compete. And only would be enforced if you, after leaving, go out and get a job in violation of the non-compete, then the employer would file suit against you, and then you would have to hire a lawyer. So make sure you read the non-compete clause, make sure you understand how it's applicable to you, so that you can ensure that you have a place to go should it not work out. I have had cases with non-compete clauses between between an employer and an employee who was a father and a son, and the non-compete was going to be enforced in any county that the father wanted to travel to make sure that he restricted the employee from being able to work in that area. So the bigger point of all of these non-competes is Florida is, as you know, an at-will state. You can be fired for good cause, you can be fired for no cause, but you cannot be fired for bad cause. And so what that means is when individuals, practitioners sign a contract that includes a non-compete, they are going to be held to that standard. And once the contract expires, for whatever period of term that the non-compete states that that physician cannot practice in that area, they will not be able to practice. There are also other elements of the contract called restrictive covenants, and that would prevent you from being able to go after, advertise to any of your former patients that you were seeing at the previous employer office. And then also any restriction on doing working for any other facility. If you're working at a hospital, they may have a restrictive covenant from working from any other facility or other entity that is owned by that facility. So the non-compete, the restrictive covenants in the state of Florida, there have been no changes to the Florida statute since 1996. It is a very pro-employer state, as one court in New York, excuse me, in New York, defined the Florida statute as truly obnoxious in one of their court rulings when they would not enforce a non-compete that was written in Florida between a Florida employer and an employee who's working for them in New York. But with that being said, Florida enforces it, and they, for the time being, like it, and they don't plan to change any of it at this point. So make sure when you are entering into these contracts, you understand the non-compete clauses, how it will affect you. It may mean at the end of the contract that you have to move to another county or travel to another county to perform the services. One sad or one other, and don't kill the messenger, I'm only relaying to you what the statutes and what the case law provides, but there's 2 points I will say. As I already said, Florida is considered the most pro-employer non-compete statute in the country, and the courts in Florida cannot consider economic hardship of the employee. So if you as an employee want to fight a non-compete and you say, but this wouldn't allow me to earn a living, well, the court will say, well, that's not a valid argument. And that's written in the statute. So when you, so make sure you read the contract in its entirety to understand all the non-competes and any restrictive covenants they have. When you're looking at the termination of the agreement at the end, or if the termination of the agreement is going to expire in 1 year, whether or not you renew, and then make sure that any renewals of that contract also include the original terms of the contract that you have, or redefine all of the terms of a new contract. Employee versus employer definitions, versus an independent contractor, and signing an agreement or a contract to work at a facility as an independent contractor is different than signing as an employee. And make sure that you understand how you are being defined, whether you're working at a facility or you're working at a local office in your area, to make sure that you are either an employee or an independent contractor, because it'll have a difference on the way the law views your relationship. Anytime you leave a employment, you want to make sure that you are provided with tail coverage. Tail coverage is insurance that goes with you from the day that you leave to the new facility or the new employee and the new employer, but it covers you for any acts that occurred while you were at the old business or the old office that have not been filed yet. Because as we know, there is an opportunity for individuals to file a lawsuit months, if not years later, after the incident or the issue presented. If you've already left that facility or that office and you're working somewhere else, you want to make sure that you have tail coverage to cover the acts or omissions that occurred at the previous employment. I think I've spoken about the addendums. I think that's good. There's a question in the chat: does non-compete end at end of time working together or at end of contract? The non-compete would, for an independent contractor, would last, it can last from anywhere from 6 months up to 2 years. The independent contractor is viewed by the court as the same as a employee when it comes to the non-compete and those restrictive covenants that last after the contract ends. It's kind of interesting because we talk about a contract and the dates of the contract and when they begin and when they expire or when they end, but a non-compete outlives the contract, can outlive the contract, so they can live for another 6 months or 2 years after the contract is ended. I hope that answers your question. If, oh, there's another, okay, sorry, I guess I didn't. If a 2-year non-compete was signed during year 1, but a new contract was never made or re-signed after the first year, the 2-year non-compete would go after the end of the term of your employment. So if your independent contract or your employment agreement calls for a 2-year non-compete, the day you leave, the 2 years begin. Whether it's in day 1 of year 1 or day 363 of year 2. The moment you leave, the 2 years begin for the non-compete. And I think we can go to the, do we have another slide? Oh, no. Okay. So
yeah.
there was one other I was going to mention, but there's another question. I'll find that. How enforceable exactly is the mileage of the non-compete? Let's say if the restriction is for 25 miles, but you find work about 50 miles, is there any room for negotiation? There's always room for negotiation. I hope everyone can read the chat box or pull it up so you can see the questions, so I don't, I'm not repeating them word for word, but you can always negotiate with your employer for those elements of the non-compete or the restrictive covenants. That is something that maybe you don't have a great position to sway them from if you're signing for 1 year right out of residency. But as you move forward, you will have more ability to negotiate for better restrictions or less restrictive restrictions when you leave. So you can always negotiate. You can attempt to negotiate before you sign it, even after you sign it. And there would be an opportunity for probably a mediation of that through the court system before it would be enforced or before the suit would be filed. But there would be a discussion about the reasonableness of the mileage and whether or not those 10 miles would cause a conflict with the statute based upon the relationship of your employer-employee and you leaving. Can non-competes be waived by the employer, or they always enforce no matter? No, they can be waived by the employer every day of the week. They can certainly waive them. Certain entities do, not all of them do, but that's up to the employer to waive it, or simply tell the employee, don't worry, we're not going to come sue you if you open up a shop 15 miles away. Just don't open one up next door. Then maybe you get it in writing and you go forward. But make sure that if it is, they can be enforced, they don't have to be enforced. I think that answers that.
And Jason, would you say that that's an example of an addendum that would be kind of referencing the contract?
Yeah, so in some of those examples, you would have the contract go for a year, and then after or towards the end of that year, they would bring you an addendum to that contract that would change the terms, maybe the salary terms and the bonus terms or any of those, and maybe change some of your benefits, but all of the other conditions from the previous contract would still be in place. So it would just be an addendum to remove or modify certain sections of the original contract. That would also revise the amount of time that the new contract would run for, or the addendum to the contract would run for.
Very good. And Jason, while you're finding out that last point that you were kind of jotting down earlier, I just like to tell everybody, again, thank you for joining us. Please hold out to the end. We have a $200 gift card, and I have to say these statistics are better than the lottery draw. So hold on to your hat. Jason, when you find your point, let me know, but I do have a question for Dr. Vakil.
Yes.
When presenting a contract to your employee, can you kind of walk out how you let them know about like a time frame, or if you have any corrections, or sign it, give it back? Like, what's the back and forth like upon giving someone an initial contract?
Let me talk about the non-compete for a second. And so,
Sure.
So we have an attorney for our corporation, and the corporate attorney does not represent me or any of my partners. He represents the corporation. Okay. So if I have a disagreement with one of my other partners and stuff, he will not represent either one of us. Okay. And all the partners have a do not compete, which is actually more than 2 years. Okay. And so the contract that the associates are signing is very similar to the contracts that the partners have. And so the reason why we have a do not compete is because if we spend the time, money, effort marketing a associate and they have a terrible image at the end of that 1 year, and if we did not have do not compete and they stayed, in all reality, the majority of the physicians, non-podiatric physicians, would still think he was part of our group and not sent to our group. On the back end, if they were a great physician and stuff, and they said, okay, I'm good, I'm going to start my own practice and stuff next door and stuff, same thing. They're not going to know that they actually left our group. And so they are still benefiting from our promoting and marketing for them. Okay, what else? Okay, and so our attorney makes up the contract, and it has most of the points that we talked about this evening. And so we usually, prior to giving them an official contract, we'll give them a breakdown of the specifics and the financials and stuff for it, and say, here, this is what we're offering and stuff. And we may talk a little bit back and forth about the actual contract and the benefits package and everything, and see if that is something that they're still interested in. And if the numbers and stuff make sense to them, then we have the attorney make up a contract that has all the other things in formality, with the CMEs and the benefits and the salaries and the bonuses and the hospital dues and the vacations and the personal time and the restrictive covenant and all the standard stuff that a contract has about duties of a podiatrist and reasons for termination. And so once we agree on the numbers and the basics of the contract, and if we both come to an agreement, then we'll send it to our attorney and have them write up a contract and send it to the associate, potential associate. And there's usually not much wiggle room on the contract once we come to the agreement with all the numbers and stuff. Because once, the do not compete is similar, or actually, the partners do not compete is actually worse than and longer than the associates do not compete. And that's just to protect the corporation and the financial viability of the corporation. To answer your question.
Yeah, I mean, sometimes it can be, a big thick thing thrown in front of you and you want to redline everything. But in all reality, I think sometimes it is a give and take, understanding, employer-employee standing and what to expect out of
Right.
this.
And it's a lot of work for a company to hire an associate. It's a lot of time interviewing and finding the right fit for your community that you've built in your office. And so it's much more at risk for us to take on somebody. And if associate joins and stuff and they don't like it and stuff after a year and stuff, they can start up someplace else if they need to. But it's once we build up an office, in a practice and stuff, it's more detrimental for us to lose an associate, because they're like a family member to us now, and so we want to keep them as long as possible and stuff, and we don't want to work forever. So we definitely want somebody to eventually buy in, become a partner, and so that we can start backing out of the practice. So it basically comes down to, you just have to trust the person and the company that you are joining.
Jason, any other points?
No, I was typing into the chat box my contact information.
Sure. So sometimes, yeah, one thing that we all talked about as a group is, when to hire an attorney. When should you have someone review a contract on your behalf? I think the long and short of it is, it's always a good idea if this is something foreign to you. It's definitely a different language of sorts. Jason was kind enough to say that he'd be a resource for folks. Certainly can provide potential contacts, I guess. And Jason, you can kind of dive into that if you like, on individuals that you may know.
Yeah, absolutely. So I can certainly provide some advice, review the contract, and give you some general advice. If you have specific questions or are in a situation in the future that you are going to terminate a contract and you want to make sure that you protect yourself, you can certainly reach out to me. There are several attorneys that I refer our FPMA members to that are well versed in those areas of practice. Unlike, well, in the legal profession, I can, once I have a law degree, I can do family law or personal injury law or administrative law or employment law, any of them. So when a case comes in or a question arises, I work with the member to make sure that we find the most appropriate attorney to review their contract or help them with their licensing issue, and then they work with them directly. I'm happy to be a sounding board for any questions or issues, and certainly point you in the direction to the right attorney that can represent you and your needs and make sure that you have the best representation feasible. And then the last thing I'll say is the best resource that I find is Google. And if you go to Google and you type in Florida Board Podiatric Medicine, you can find links. You'll find the board website, and through there you can find links to the Florida statutes, the Florida rules for podiatric physicians, and make sure that you are understanding what is required of you with your license, and then make sure if you want to do anything or make any changes to your employment status, that you comply with any rules that are out there as far as notice and leaving offices, so forth. That's all I will say, I think.
Great, thank you. And I see a hand raised. Andrea, if you don't mind just texting your question in the comment box or the chat box, that would be great. And on that note, I would like to thank FPMA for this opportunity. You know, I think keeping a pulse on what's going on from a young physician standpoint is very important, because this practice of medicine is ever changing. I like to thank Karen for joining us, as well as Alessa, staff from FPMA. Please keep your ear to the ground, eyes on your inbox per se, for other opportunities that are both virtual as well as in person. For example, at SAM 2022, it's going to be awesome. We're going to have a ton of opportunities to get involved. We do have the yearly poster competition, as well as the young practitioner presentations, and that'll be held on Friday of SAM. And we are going to host our first Berry student competition that Saturday. If you are interested in participating, please reach out to us. All of our contact information is readily available. We're just happy to get people involved, get people plugged in, get you the information you need to succeed. On that note, I mean, that's all I have. We are going to announce our winner momentarily. If our other presenters don't have anything else to add, I'd like to kind of hand it off to Karen if you'd like to say anything.
Dr. Schmidt, we might want to take Dr. Cyrus's question first.
So yes, in the chat box, the question from Dr. Soares, and I apologize, that's probably butchering your name, but how do non-competes work? Is it normal to negotiate a zero non-compete? I would say if you are lucky enough to do that, then you would be one of the few, but I'm surprised every day by people. So it just depends on where you're going to work, who you're going to work for, and how restrictive or I don't want to say, well, how restrictive they want to be, and then how poorly it turns out. Because if it goes bad, then I'm certain the employer would do everything they could to enforce the non-compete. If it goes great, then maybe the employer wouldn't want to enforce the non-compete. But to be able to negotiate a zero time frame for a non-compete in the very beginning is probably unlikely. Possible, but probably unlikely. If you could get it, 6 months or a year. I understand that once 6 months, 1 day or 6 months is equivalent to 2 years, because you're going to have to go somewhere else and start over anyway. But unfortunately, that's the way the statute was written, and that's how the courts in Florida have enforced it. Are non-competes part of residency contracts as well, or just for actual employment? It's just for actual employment afterwards.
Right.
I don't know that there's any. I've never seen a residency contract with a non-compete, but yeah.
No.
Yeah, one of the first contracts you might come across is what defines your residency program, but most of that is standardized through the hospital. It's not competitive. It's mainly for educational purposes. So they're not trying to block anyone, though it is common to set up practice outside of residency programs. So I can understand your point. And sorry, Andrew, I didn't see that your text box came up when I was talking.
So thank you everyone for joining us this evening. I would like to thank FPMA General Counsel Jason Winn, Dr. Larissa Schmidt, and Dr. Samir Vakil Thank you all for your time. It is my pleasure to announce our $200 American Express gift card winner, Dr. Joseph Watson. Congratulations. With that, I think we are concluded. Thank you all for attending. Have a good evening.
Thank you.
Thank
Great
you. Have a
night.
great night. Stay safe.